Hello, I'm Paolo Cavaliere and I'm sharing some tips on how case law analysis can be used to develop a deeper understanding of legal provisions and better arguments for your memorials. For instance, imagine you're dealing with the principle of pluralism in Europe and you want to understand how it's acknowledged and applied in the European sphere. At this point, the first and most obvious thing to do is to give a look at the relevant provisions. You know that in Europe we have two conventions dealing with freedom of expression: the European Convention of Human Rights and the Charter of Fundamental Rights of the European Union. These are two separate provisions applied by two separate courts with different jurisdictions. Nevertheless, the two wordings look pretty much similar to each other because the Charter of Fundamental Rights was drafted on the example of the European Convention. So if you look at the first two paragraphs, you will find that the wordings are absolutely the same. If you look further, you will find that while the European Convention has no acknowledgement of pluralism at all, you can find the word in the second paragraph of the Charter of Fundamental Rights. At this point, you might have reason to believe that pluralism receives a stronger protection under the Charter of Fundamental Rights. But if you look and you compare the two case law systems of these two courts, you might be surprised to find that this is not quite the case. This is a very basic storyline of the case law of the European Court of Human Rights on the issue of pluralism. Although, as we saw, there's no explicit acknowledgement of the principle itself in the relevant convention, is it possible to see how through the years the court has managed to achieve significant results in the protection of pluralism? Starting from a very basic understanding of pluralism as a plurality of different voices in the media sphere, it has progressively acknowledged a much broader scope for the principle itself. For instance, acknowledging that pluralism is also differentiation on the cultural, linguistic and religious perception in the society that the media sphere should represent, and also encompassing linguistic diversity within the broader umbrella of the idea of freedom of speech. Also, it's very important to note how the Court of Human Rights has managed to get closer and closer through the years to the idea that the value of pluralism is a sort of individual rights that the court has a duty to protect. Back in 2009, for instance, it has managed to find the value of pluralism as an individual right vested in the principle of freedom of speech, even without an explicit acknowledgement of it in the Convention. So, by having a look in depth at the case law of the European Court of Human Rights, it is possible to state that even if there's no explicit acknowledgement, the court has managed to develop a broad understanding of pluralism from a number of different perspectives, not just external pluralism, but also pluralism in the sense of a diversification of representation of the society, and also has managed to find that the Article 10 of the Convention protects pluralism as a right to receive differentiated information that protects individual positions. If we compare the case law of the European Court of Human Rights with that of the European Court of Justice, we will find that in this case the court has been less far-reaching than the European Court of Human Rights. For instance, it has never gone as close as the other court has done in acknowledging pluralism as an individual right. Back in the 90s, it was considered as a positive right held by the broadcasters, basically. So it would amount to something closer to the freedom to provide services than to an individual right to receive a diverse information. Also, you can see how the case law of the European Court of Justice has not developed in a straight line as the other court has managed to do. Back in 1994, the European Court of Justice seemed to reach a similar point to that developed by the European Court of Human Rights by saying that freedom of expression and diversity of opinion are precisely what the general provisions for free speech are supposed to protect. But then, more recently, in 2007, the court has taken a significantly different position and has said that pluralism in the end is just connected to the value of freedom of speech, but it's not technically the same value and it's not technically an individual right. So, despite having a much more explicit provision to operate, the court has demonstrated to be way less far-reaching than the European Court of Human Rights in recognizing pluralism as an interest or even as an individual right of citizens. Another thing you want to do is try to frame the decisions you're analyzing within their historical background. In this case, for instance, you can see that the European Court of Justice has had chance to decide on two very similar cases on national regulations of advertising frequencies. Although the two cases were so similar, the grounds for the decisions are incredibly different. In the first case, the court has decided on the background of the freedom to provide services, while only in the second case, the value of freedom of speech has been brought inside the background for the decision. The reason is that back in 2000, in between the two decisions, the European Charter of Fundamental Rights had been passed. And although it had no legally binding force yet, it had already some sort of influence in making the court more aware of the importance of freedom of speech as a fundamental right within the European sphere. Another thing you want to do is to have a look at whether most recent decisions appear to sit at odds with the previous ones you have analyzed in preparing your memorial. In this case, it might be the case that you grasped some sort of developing trend, that you find that something is moving and is changing in the appreciation of a value by a court, and you want to use this most recent case to show how things are changing through the years. So legal provisions on paper can be misleading at times. You want to make sure you had a deep look at the relevant case law and you understood how these provisions are applied in practice. I hope this has been useful. Best of luck to you and your team.